Thank you, Chair. Thank you, and good afternoon, Dr. Hardy. Thank you so much for providing the submission. Now, the Fair Work Ombudsman has submitted that, and I quote, "It is not unusual for new penalty regimes to take time to reach the courts, particularly in the criminal context." Now, they cite the example of the serious contraventions which were introduced in 2017 and not brought before the court in 2019. Do you believe this is a fair comparison?
I do. I mean, in the sense that in relation to new provisions, such as the serious contraventions amendments that took place under the Protecting Vulnerable Workers reforms, or more recently, the way in which the serious contraventions provisions been amended under the closing loopholes reforms, it's very rare for them to be retrospective in nature. The same is true, of course, of the criminal offence in relation to intentional underpayment. And because they are prospective in nature, it does take some time for there to be a case which is of sufficient seriousness that would justify bringing either litigation with respect to serious contraventions or a prosecution with respect to the criminal offence. It is intended that these are reserved for the most egregious or serious cases, and therefore it does take time for those cases to emerge.
Yep, so it could be years until a criminal wage theft case comes before a court, right?
Yes, I think that's quite possible. Yes, because the relevant offence needs to take place after that provision takes effect, which of course with the criminal wage theft offence was 1 January 2025.
Yeah, no, absolutely. Now, just in the centre's submission, it says it is to be expected that some time must pass following the introduction of the offence before an underpayment occurs, which is of sufficient seriousness and quantum to warrant a criminal investigation and prosecution. Do you believe it is necessary for the Fair Work Ombudsman to employ 16.7 full-time equivalent staff to solely investigate criminal wage theft matters, or would better outcomes be achieved by putting those resources into civil underpayment investigations and only conducting criminal investigations where, as the centre submits, and I quote, "denunciation and condemnation is required and where the deterrent effect of a civil penalty would be insufficient"?
Yeah, thank you. I mean, it is difficult to answer the question around the number of staff that should be dedicated to a particular jurisdiction. What I would say is that, in effect, what the Fair Work Ombudsman now has responsibility for is a dual-track system that's got the criminal jurisdiction as well as the civil jurisdiction. And the nature of that dual-track system means that there needs to be fairly firm procedural boundaries between the teams that are dedicated to the investigation of criminal matters as opposed to the investigation of civil matters, because any tainting of the investigation that's being undertaken with respect to the criminal offence might compromise the capacity for the prosecuting authorities to initiate the prosecution or to succeed with respect to that prosecution, because the evidentiary requirements with respect to criminal investigations and criminal prosecutions are by their very nature much stricter. There's higher privileges, higher burdens of proof. I'm sure you're familiar with some of those issues. So I think certainly in the inception of a new jurisdiction, I don't think it's unexpected that you would have a dedicated team of 16.7 staff to try and ensure that you've got sufficient expertise on the ground to undertake those investigations with due care and skill.
Yeah, and just quickly on Victoria's wage theft laws, which, criminalise not only wage theft itself, but also the dishonest destruction of failure to keep payment records. Should stronger record-keeping requirements be considered as a way to make the wage theft offence a more effective deterrent?
Yeah, look, it's a really good question because it is, I think, well established now after having, a fairly established regulator in this space for more than 15 years, that records are essential to bringing an investigation and bringing litigation that's seeking to enforce entitlements. My sense is that the presumption that applies where records have not been kept or have not been accurately kept can sometimes be more helpful. So this is the presumption that was introduced under the Protecting Vulnerable Worker reforms. That presumption does not exist with respect to the criminal offence. So yes, you can attach a criminal sanction in relation to intentional destruction of records. That might be something for consideration for those involved in law reform. But at the end of the day, proving a criminal offence of intentional underpayment is going to be more complicated when no records have been kept or there's been intentional destruction of them. So certainly you could attach a separate criminal sanction to that separate offence, and that might lead to sort of a heightened level of deterrence. But as indicated in my submission, I mean, my sense is that criminal sanctions only get you so far when it comes to deterrence, and certainly the research and evidence suggests that there's other ways that are possibly less appealing from a political point of view that actually serve deterrence purposes very well, and that's increasing the perceived risk that you're going to be detected, and if you are detected, you have a perceived risk that a sanction, even a modest sanction such as a fine, a small fine, will be imposed. So the evidence suggests that that is the better way to deliver deterrence. But of course, there's that separate question of deterrence is only one part to promote compliance. So all these things are kind of, I think, important to distinguish between when we're talking about whether or not we're seeking to promote compliance as opposed to enhance deterrence, and what's the best way of achieving both those aims.
Yeah, no, absolutely. And we heard from witnesses just earlier to the committee in sectors like higher education, wage theft doesn't come through a boss taking a bit of money out of a payslip, but through institutional practices like the normalisation of a culture of unpaid labour and forcing workers to go far beyond what is expected of them in order to be eligible for a promotion. Like, do you believe wage theft offence is drafted in a way that effectively encapsulates conduct that constitutes what most people would think of as wage theft?
Yeah, I mean, this comes down to what is the definition of wage theft, because we don't have one in the Fair Work Act. And certainly some of the submissions that I saw from colleagues at the University of Newcastle put forward some really interesting research around the extent to which work is remunerated and paid for. I think the question that I have is the extent to which that work constitutes a breach of the relevant industrial instrument, and so to what extent is there an underpayment that can be the subject of civil enforcement litigation or a criminal offence. So that's sort of the first kind of key question, I think. But assuming that it does constitute a breach of the relevant industrial instrument, then I think in terms of the criminal offence in the Fair Work Act, it's directed at intentional underpayment, but intent is defined very broadly under the criminal code to include a corporate culture. So this is one of, I think, many unresolved issues with respect to the criminal offence that would have to be resolved via decisions about the way in which that corporate culture element will be interpreted and applied in the context of an intentional underpayment. So universities is one example. Of course, there's many others in other sectors of where there might be a corporate culture that has tacitly authorised underpayment.
Yeah, no, absolutely. Chair, do I have quite time for one more question?
One very fast one.
Thank you. Just a quick one. So organisations like SDA and NTU have proposed that, you know, unions should be allowed to investigate and possibly refer criminal wage theft matters to the police. What are your thoughts on that proposal?
Look, I think going back to what I was saying before in terms of the importance of increasing the risk of the perceived risk of detection is really instrumental to enhancing deterrence. Certainly unions have had a historical role in our system in terms of detection, and I think there is scope for providing them with the capacity to refer. I mean, at the end of the day, it's going to be the prosecuting authority, whether it's Australian Federal Police or the Commonwealth Department of Public Prosecutions, that ultimately decides whether or not a prosecution will be initiated. So a referral is one thing, but they too would have to abide by criminal rules of procedure in order for that brief to be accepted, presumably by the prosecuting authority.
Yeah, thank you so much. Thank you, Chair. Appreciate it.